Hi, good afternoon, and thank you for joining us for today's COVID-19 topic, paid leave in the age of coronavirus. My colleague Maury Raskin and I will be covering key points under the leave provisions of the Families First Coronavirus Response Act, specifically the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act, which focuses on the family leave portion of that. We have a lot to cover, and so we'll just jump right into it. Next slide, please. Thank you. The Emergency Paid Sick Leave Act covers 6 specific qualifying reasons for emergency paid sick leave. And one of the key points here is an employee would qualify for emergency paid sick leave if they are unable to work or telework, and we'll get into that later, for one of the following 6 reasons. The employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. And that can include, for example, the current stay-at-home orders by Governor DeSantis and by other governors throughout the United States. And again, it's if the employee cannot work or telework as a result of the order. Also, an employee is entitled to emergency paid sick leave if they have been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, or the employee is experiencing symptoms of COVID-19 and they're seeking a medical diagnosis. Additionally, an employee is entitled to emergency paid sick leave if they are caring for an individual who is subject to the local, state or local quarantine or isolation order related to COVID-19, or they are caring for a person who has been advised by their healthcare provider to self-quarantine. An employee also can take emergency paid sick leave if they are caring for their own son or daughter who is under the age of 18, if the son or daughter's school or place of care has been closed, or the child care provider, such as a nanny, is no longer available due to COVID-19. And finally, if the employee is experiencing any other substantially similar condition specified by the government in consultation with the Secretary of the Treasury and the Secretary of Labor. Really, the first 5 are the key issues that most employers are dealing with. Emergency paid sick leave is for all employees of the employer. It does not matter if they are full-time, part-time, intermittent, intern, seasonal. It does not matter if they became employed by you yesterday or have been employed by you for years. Everyone is eligible if they cannot work or telework for one of these 6 reasons. Next slide, please. So how much leave do we have to provide? Emergency paid sick leave for full-time employees is 80 hours. It does not all need to be taken at one time. An employee, for example, who is experiencing symptoms and needs to obtain a diagnosis might only need 24 hours or more. If they're experiencing symptoms, they take a day off. They need to go and get their test, and then they get their test results, and it turns out they're negative. That's fantastic. They don't need the full 80 hours. They only need the hours they need, and then they still have the remaining period of time, 80 minus whatever hours they took of leave remaining. Full-time, for purposes of this law, is someone who is regularly scheduled to work at least 40 hours. And that's different from other laws we have where there are different hourly requirements. So part-time in this example, and under this law, is someone who is regularly scheduled to work fewer than 40 hours a week. And we look at, it's actually not the average number. If they have a set schedule, we look at what their set schedule is over a 2-week period, and that's going to be the number of hours of paid leave that they're entitled to take. And then if a part-time employee does not have a set schedule, then the regulations provide a formula as set forth here. Next slide, please. How much does emergency paid sick leave cost? An employee using emergency paid sick leave for the first 3 reasons we discussed before, which really relate to their own care. They themselves cannot work or telework because they're subject to a quarantine or isolation order, or they've been advised to quarantine by their healthcare provider, or they themselves are seeking a medical diagnosis because they are experiencing symptoms of COVID-19, they are entitled to full pay at their regular rate, capped, however, at $511 per day and $5,110 in the aggregate. If an employee is using emergency paid sick leave for the other 3 qualifying reasons, to care for someone else, to care for their own son or daughter whose school or daycare is closed, or for that other, as yet defined reason, then it's 2/3 the employee's regular rate of pay. And sick leave in that case is capped at $200 per day and $2,000 in the aggregate. Next slide, please. So to recap, the first 3 reasons, which pertain to the employee's sort of own situation, that is full pay subject to the cap. And then reasons 4, 5, and 6, which pertains to the employee needing to care for someone else, it's at 2/3 pay subject to the cap. Next slide, please. Okay, for each hour of emergency paid sick leave taken by an employee, the employer shall pay the higher of the employee's average regular rate of pay for the 6-month period prior to the first day of leave. Or the federal minimum wage, or if you live somewhere that has a higher minimum wage other than the federal minimum wage, then we look at what that state or local minimum wage is. And so it's the highest of those 3 numbers. That is the rate that the employee needs to be paid for their sick leave, either at 100% or at 2/3, depending on the qualifying reason for the leave and subject to the applicable caps. Next slide, please. Okay, a few key points. The Fair Labor Standards Act, which normally dictates how we have to pay our employees, still comes into play, but there are a few exceptions here. Exempt employees, who normally need to be paid on a salary basis, can have their salary prorated for sick leave if they only need to be paid at the 2/3 rate, and that does not destroy the exemption from overtime. Similarly, if an employee earns the minimum wage, or they earn a non-exempt employee, and they either earn the minimum wage or they regularly earn a little bit more than the minimum wage, and they are taking emergency paid sick leave for a reason, a qualifying reason that entitles them to 2/3 of their pay, then the fact that their rate is now dropping below minimum wage does not impact there's no Fair Labor Standards Act impact. Plus, the employee is not actually working. So those hours wouldn't count towards overtime anyway for a non-exempt employee. So the real impact here is that you're not losing the overtime exemption for exempt employees because you're not paying them their full salary for any week that they're taking paid sick leave and receiving only 2/3 their regular rate. There's also a healthcare provider exclusion that allows an employer to exclude certain employees in the healthcare field from having to provide to them emergency paid sick leave, as well as the emergency family and medical leave. And Maury will cover the healthcare provider exclusion more in his presentation. It is important to know that Congress has expressed dissatisfaction with the Department of Labor's rules with respects to the healthcare provider exclusion and also some other regulations that pertain to how employers are to implement and carry out these new leave laws. But until the regulations are changed, they are what we have, and employers need to adhere to them. And to the extent the regulations are helpful to employers, then we can take advantage of them as well. There's also a small employer exemption that Maury will cover in more detail. But as far as emergency paid sick leave goes, I do want to point out that it is limited only to the requirement that an employer provide leave under the child care qualifying reason. So small employers in this case are employers with fewer than 50, and a small employer must provide emergency paid sick leave for all of the other 5 qualifying reasons, but may elect an exemption to providing emergency paid sick leave to an employee who needs to care for a son or daughter whose school or daycare is closed. And importantly, small employers must still provide or still post notice of the leave rights so that employees are aware. Next slide, please. Okay, helpfully, employees may, but are not required to use emergency paid sick leave before using any other paid leave benefits. So often an employer can dictate the order in which an employee is taking leave, but in this case, they cannot. An employer cannot tell an employee who qualifies for emergency paid sick leave to use their regular paid leave benefits first. That is the employee's choice. Emergency paid sick leave does not carry over from year to year. It is not paid out upon the employee's termination from employment for any reason. The employer must post notice, similar to the broken arm poster for workers' comp and the minimum wage poster and some of the other posters that are required. Today, though, posting in the break room may be insufficient because if employees are not working at the workplace and are not there to go and see the poster, it might be necessary to disseminate notice of these leave laws through other means, electronically, email, posting on the intranet, a company's intranet. The Department of Labor has provided a model poster that employers can use to make sure that they are presenting the correct information to give notice to their workforces. The Emergency Paid Sick Leave Act expires at the end of this year, December 31st, 2020. It is always possible as things play out that this could be extended, but right now the requirement to provide the leave to a qualifying employee for a qualifying reason expires at the end of the year. Paid leave is initially paid by you, the employer, but it is to be paid by the federal government via dollar-for-dollar payroll tax credits. And we do recommend that employers consult with their accountants and financial advisors to understand how that works so that they can take advantage of that. Employers may not use payroll protection program loan proceeds to pay for the emergency paid sick leave. And this is because it could be considered double dipping because you're getting hopefully a forgivable loan to pay for payroll and benefits. And so if you were also to receive payroll tax credits, that's where it could be considered double dipping. So these are two different laws. We have the Families First Coronavirus Response Act, which provides for the emergency paid sick leave, and the family leave, where you can get reimbursement through dollar-for-dollar payroll tax credits, again, separate from payroll protection program loan proceeds. Next slide, please. What happens if we don't comply? A company can be sued. Employees who believe that they were denied emergency paid sick leave or who believe they were retaliated against for requesting or taking the leave have the same ability to pursue an action against their employer as if they were not paid minimum wage or overtime under the Fair Labor Standards Act. So that could be unpaid wages, liquidated damages in an equal amount to the unpaid wages, attorney's fees and costs. So it's important for employers to understand what their obligations are and to provide and pay for the paid sick leave when an employee is eligible and entitled to it. Next slide, please. So a few questions. Is an employee permitted to use regular paid leave benefits to receive full pay for a qualifying reason that entitles them only to 2/3 pay? Yes, an employer can allow an employee to use their regular paid leave benefits. In this case, though, if you did that, if they were using their regular paid leave benefits, the employer can still only obtain the payroll tax credits for the 2/3 pay that were part of the emergency paid sick leave. The employer cannot claim tax credits to be reimbursed for normal paid leave benefits that the employee is using. Again, I encourage everyone, all employers, to consult with their tax advisors and accountants to understand how the reimbursement through payroll tax credits work. May the company voluntarily and out of the goodness of their heart supplement the 2/3 pay so that the employee receives full pay? Yes. An employer always can choose to do that. What is unclear, though, is if the employer will be able to be reimbursed by the federal government through the tax credits for the additional funds. And so again, please consult with your tax advisors and accountants on that issue. What does a quarantine or isolation order mean? It's an order that puts an employee in a position of not being able to work, even if work is available for them. It's different from teleworking. So skipping down to number 7, what does telework mean? That is work that can be performed away from the regular workplace if the employer has the work available and permits the employee to perform the work. A quarantine or isolation order also can be an order that is directed to a particular category of individuals. And in Florida, the governor's stay-at-home order has a provision that says senior citizens and individuals with a significant underlying medical condition shall stay at home and take all measures to limit the risk of exposure to COVID-19. The order says senior citizens and individuals with a significant underlying medical condition shall stay at home. So if an individual that fits within that category is unable to work or telework, then they would be eligible for emergency paid sick leave under this law. If an employer, though, has furloughed their employees, so there is no work for them, employees are not going to be entitled to emergency paid sick leave. It's only if work is available for them and they are unable to perform the work either at the workplace or remotely via telework because of the quarantine or because of one of the qualifying reasons. Employers can require documentation to support a request for the emergency paid sick leave. They do not need to have a doctor's note per se. That was an important provision because of the burden currently on healthcare providers and not wanting to send employees out to a doctor's office to go get the note. But there is information that an employer can require the employee to have when they request the leave. So the employer can require an employee to provide documentation with the employee's name, the dates for which the leave is requested, the qualifying reason for the leave, and an oral or written statement that the employee is unable to work because of the qualified reason for the leave. And if the employee is taking leave because a healthcare provider has recommended that they quarantine, or because they're caring for an individual whose healthcare provider has recommended that they quarantine, then the employee can be required to provide the name of the healthcare provider. So there is documentation that the employer can request and maintain. In most cases, it would need to be maintained in a confidential medical file for the employee to support their emergency paid sick leave. When an employee returns to work, if they have not used all of their paid sick leave, then through December 31st, 2020, they will be entitled to use the remaining amount of paid sick leave for any of the qualifying reasons. If they've been furloughed and then they return to work up until December 31st, 2020, they will also have the ability to use emergency paid sick leave if a qualifying reason arises between now and the end of the year. Next slide, please. So that was our overview of the Emergency Paid Sick Leave Act. We will get to questions at the end of Maury's presentation, but I now turn it over to Maury Raskin to cover paid FMLA under the Families First Coronavirus Response Act. Thank you.
Good afternoon. Thank you for attending. While I've been doing this for 38 years, this is my first foray into this forum. So I hope that I can communicate effectively with you, and I will be checking the Q&As at the end to see if we need to double back. Next slide, please. Who is a covered employer for purposes of providing paid FMLA leave under this new law? And it applies to any employer of 499 employees or less. The count is taken on a rolling basis on the day the employee's leave is to start. If a company shrinks and an employee of a 500-person company or less took leave and then, I'm sorry, I said shrink, but if the company actually grows, the leave still continues. So if you're out on leave and your company has actually grown above 500, you would finish your leave. The count includes all full-time and part-time US-based employees. It includes employees hired through a temp agency, through a PEO or that type of organization. So it is covering all US-based employment. Next slide. Some companies are integrated and they operate multiple facilities, or they operate separate and distinct, let's say restaurants. Two entities that are ordinarily separate could be considered one employer under this law. And that's the integrated employer test. If there are multiple companies, they can be counted as one employer. It is a fact-specific inquiry. Is there common ownership? Is there common management? Is there a common business purpose with day-to-day business operations? And it becomes an important question, and I've spoken with many employers for the purpose of seeing if they have more than 500 employees when they are integrated. So it is possible. Next slide, please. There is also, as Rachel mentioned, a small employer exemption under the FMLA portion of the law. The exception opportunity exists for companies or employers of less than 50 employees. Where the exemption will be claimed, the employer must write a letter which justifies the exemption and details why paid FMLA would jeopardize the continued viability of the company. Regulations that have been published by the Department of Labor detail exactly what must be asserted and the support that's necessary to sustain the exemption. And I can just read a portion of that to you. The justification would have to provide that such leave would cause the small employer's expenses and financial obligations to exceed available business revenue and cause the small employer to cease operating at a minimal capacity, or that the absence of the employee or employees requesting the leave would pose a substantial risk to the financial health or operational capacity of the employer because of their specialized skill, knowledge of the business, or responsibilities. And finally, that the small employer cannot find through enough other workers who are able, willing, and qualified, and who would be available at the time and place needed to perform the labor or services that the employee or employees requesting leave otherwise provide. If you can meet that burden, you can write a letter and seek the exemption. The way that's done is to prepare the letter, detail the reasons why you meet the exemption, including exhibits or justifications, and then hold on to the letter. You don't submit the letter. You reject the requested leave, and you hold on to the materials. As Rachel said in her presentation, you still must comply with the poster requirement and notify employees of their opportunity to claim extended FMLA. And you notify them of your intention to claim the exemption when the leave is requested. And then you hold the material and the paperwork for use if and when you're ever questioned about it. Next slide. Which employees are eligible to claim expanded FMLA and paid FMLA? It applies to all full and part-time employees after 30 calendar days of employment. Those of you who are familiar with FMLA otherwise know that there's a 1 year and 1,250 hour work requirement that no longer applies. The only threshold is 500, 499 or less employees and 30 calendar days of employment. Importantly, if an employee is terminated after March 1st and rehired before December 31st, and if they've worked 30 or more days within the 60 preceding calendar days prior to their termination, they too would qualify. So if you furlough an employee and bring them back, they're going to be eligible depending on their prior employment record. Next slide. What exceptions apply? There are two. I will talk about the healthcare exception in a second. The other one is for first responders, meaning police, fire, that sort of thing. But the healthcare exception is very broad and defined in the regulations as anyone employed in a doctor's office, hospital, clinic, school which offers healthcare education or instruction, a nursing facility, a retirement facility, a nursing home, a home health provider, a lab, a pharmacy, or any other similar institution. If you fall within that broad definition, you have an exemption or exception that you can claim for this law. Next slide. What pay must be made for people claiming this leave? As Rachel talked about, the first 2 weeks or 10 days are unpaid because they fall under the Sick Leave Act. The employer has to abide by the employee's election to use available paid leave. The last 10 weeks are paid at 2/3 of the employee's average rate of pay, other than discretionary bonuses over the last 6-month period, up to a maximum of $200 a day and a $10,000 total. You can pay more pursuant to a more generous policy, but the tax credit that flows from this law is limited to the $200 a day and $10,000 aggregate total. Next slide. The reasons for the paid or expanded FMLA under the Family First Coronavirus Act is only applicable if a minor child school or child care facility is closed due to the pandemic. If your employee is absent from work for that reason, they are eligible to receive the pay that we talked about just a minute ago. Otherwise, they may be eligible for traditional FMLA if you are an employer for whom traditional FMLA would apply. The only reason for paid FMLA is because school or child care is unavailable due to the pandemic. Next slide. The law did not change how much time is available. It remains 12 weeks in a 12-month period, expiring on December 31st. The new law did not expand 12 weeks. So if an employee had taken time off within this period of time for a different FMLA event, that would be subtracted from the available time remaining. It is a total of 12 weeks in a 12-month period. Next slide. What about intermittent leave, which we sometimes talk about with FMLA leave? In this instance, it is only if the employee and employer agree. And again, it is only if the reason for the leave is for the employee's need to care for a minor child whose school or childcare facility is closed. Next slide. What happens at the end? The employee must be returned to the same or an equivalent position. If, however, the company underwent some adverse employment action, there was a layoff or a furlough, the affected employee could be included in the layoff or furlough if they had not taken FMLA, if they otherwise would have been included. The burden of proof is on the employer to show that the employee would not otherwise have been employed at the time of reinstatement. Next slide. There is an exception to job restoration for small employers of 25 or less who do not have to return an employee if 4 conditions are met. The leave was taken because the son, daughter, school, or childcare facility was unavailable. The position no longer exists due to the economics or operating conditions. The employer made reasonable efforts to restore the employee to the same or an equivalent position. And significantly, the employer's reasonable efforts to restore employment fail. The employer makes reasonable efforts for a year to contact the employee if an equivalent position becomes available. And the year period of time is measured from when the leave ended or 12 weeks after it commenced, whichever is earlier. You have to meet all 4 conditions in order to benefit by this exemption. Next slide. What is an employer's record-keeping obligation? An employee can provide an oral statement to request their paid sick leave or expanded FMLA leave. The employer is then required to document that request and retain it for 4 years. The employer must retain all documentation provided to employees for 4 years, regardless of whether the leave is granted or denied. That goes back to the exemption requirement earlier for small employers. If the request is denied, again, because of the small business exemption, retain it for 4 years, including the justification letter that the requirements of the exemption are satisfied. Next slide. So we will, if you give us a second, we will go through the Q&As that have been submitted and we'll talk about them. But that final, finishes our summary of the two sides of this law.
Great, thank you, Maury. So we have a number of really good questions. And I think, Maury, do you want to begin? Or do you want me to take them as they come?
However, I know that one of the questions that was submitted in advance of the presentation was, when do these leave laws apply? And if it's sick leave, they apply immediately. And if it's FMLA, it's upon 30 days of employment.
Right. There was also a question about employees working some hours and then taking the FMLA for the remaining part of the day to care for the children. Would that be permitted, Maury?
It's an interesting question. If the child care facility is closed, it is possible if the employer agrees to it. And if there's agreement, then intermittent leave would be okay. Both parties have to agree for intermittent FMLA under this law.
We also have a question about whether employees have to use the emergency paid sick leave to get paid. Does the employer have to fund the leave regardless of available personal time off or vacation that's already on the books? And it's a bit of a hybrid question because the new leave law makes it clear that an employer cannot terminate an existing paid leave plan or policy because of these new leave laws. These are in addition to whatever types of sick leave, vacation time, or other PTO benefits that an employer might provide. So what emergency paid sick leave provides is an additional up to 80 hours of leave for the 6 qualifying reasons. An employer cannot take away or deny an employee the right to use any other available sick or any other available paid time off or paid leave benefits that the employer provides anyway, pursuant to the terms of those policies. So an employer is, if there's an employee who qualifies for emergency paid sick leave, the employer does need to provide that leave if the employee requests it and demonstrates that they're eligible for it, that they qualify for it. And then the employee will also have the right to take any normal sick leave, vacation time, personal days, or whatever else it is that the employer provides in the ordinary course.
And I will ask a question on this point, and it's a takeoff on one that was submitted. Rachel, what about an employee who has taken 2 weeks or 80 hours and then later has a health-related incident relating to COVID? Is there a quote, second eligibility?
No, there is not. So under the emergency paid sick leave, it's 80 hours up to, because if they're part-time, it will be less than that. If they normally work more than 40 hours a week, then the employee is still capped at 80 hours of emergency paid sick leave. And that is all that they are eligible to use through December 31st, 2020. So if an employee uses their 80 hours for one of the qualifying reasons, and then later in the year, they have another qualifying reason, they do not get a second 80 hours of emergency paid sick leave. They might, however, fall back on traditional FMLA.
Right.
If the employee otherwise qualifies for that. So you have a large employer, more than 50 employees within a 75-mile radius of where the employee works. The employee has worked for more than 1 year and at least 1,250 hours in the last 12 months. And the reason that they need the leave is because of their own serious health condition, or because they have to care for a family member with a serious health condition, even, you know, COVID-19 related. But the emergency paid sick leave, they will have exhausted that. And so they are limited to whatever traditional FMLA leave would provide to them, and that is an unpaid leave.
Right, because that would not be predicated upon a school closing or childcare facility being unavailable, which is the only reason you would qualify for paid FMLA under this law.
Right. We also had a question, Maury, about whether if an employer hires an employee tomorrow or in August, is the employee automatically entitled to the 80 hours of emergency paid sick leave regardless of their date of hire? And the answer to that is yes.
Right.
And the way this particular law was written, the emergency paid sick leave is available to all employees regardless of their date of hire. So if you employ them now or employ them later in the year, they will have that available to them for a qualifying reason.
Right. And one of the questions was, how is child defined for this law? And initially, the answer was someone under the age of 18. The regulations that have come out since then have, for lack of a better word, expanded that to talk about individuals who may not be able to care for themselves, but are over the age of 18.
Correct. And it doesn't have to be the employee's own biological child. It can be their foster child, their stepchild, a legal ward. But also for purposes of caring for the child whose school or daycare is closed because of COVID-19, it is only if there is no other suitable person available to care for the child. And so that can, if an employer is employing both parents, then both parents would not be eligible, presumably, to take this expanded FMLA leave to care for the same child, because the law is presuming that only one person needs to care for the child and not two.
What about the request by a married couple in a traditional sense for sequential leave to care for that child?
I'm sorry, Maury, that didn't come through clearly. Could you?
So where an employer employs both parents, are each of the individuals eligible for 12 weeks, so they sequentially get 24 weeks? Or is it a maximum of 12 weeks for that minor child?
And here I'd have to look at the regulations again. I believe that this is one of those situations where the traditional FMLA regulations say that both parents, if they are employed by the same employer, get a combined 12 weeks of leave upon the birth, adoption, or foster care placement of a child. But in this case, I did not see, but I would need to confirm, that there is no extension of this new expanded FMLA to that same principle.
No, I'm in the same position. I've simply not read anything on that issue. I haven't read that the law has not changed, and I haven't read that the law has changed.
Right, and so, I mean, the way it reads, it appears then that both parents would each be eligible for up to 12 weeks to care for the child whose school or daycare is closed, but not at the same time, because only one parent needs to actually care for the child. But we have a related question that also is not entirely answered, right. And that is, what do we do this summer? Schools will be out. I mean, they're out anyway, but the distance learning will have concluded. So the schools are not closed because of COVID-19, they're just closed. Daycare, other childcare, summer camps, however, may not be available because of COVID-19. So does the expanded FMLA or even the emergency paid sick leave that deals with childcare, does that expand into the summer? And you know, that's
I think
a
it's
bit of an unknown for a
right.
variety.
It's a chapter to be written.
Correct. I mean, Congress, I think everyone was hoping and expecting that this COVID-19 situation would end sooner than we now know it will end. Similarly, the payroll protection program, contemplate, which is outside the scope of this seminar, but it's 8 weeks worth of payroll. And we all now know that not all businesses are going to be able to open in 8 weeks. They might, we're not sure. So similarly, the need for this expanded FMLA and the emergency paid sick leave as it pertains to caring for a child whose school or daycare was closed may run into the summer months, and it's not entirely clear how that is intended to be applied, because again, the schools aren't closed. And while some summer camps may elect not to open, there could be some other summer camps that are open, and a parent may not be able to get their child into a summer camp because of capacity. Or if a parent is choosing not to send their child to summer camp because of their concerns about their child being in a large group environment like that, that is not what this act is intended to cover.
Correct.
So there are some unanswered questions that we either hope will be answered by the Department of Labor or that otherwise we'll have to figure out and navigate, and definitely fact specific as to what exactly is the individual circumstances that are leading them to request the leave in the summer months. Okay.
Rachel,
oh, sorry, go ahead.
No, I was reading a sick leave question that somebody has posed, that is an employee works 28 hours. I'm not sure what they mean at the beginning of the week. They average 43 hours per week. How is the sick leave calculated? I guess it's for an employee with a variable work schedule.
Okay, if the employee has a variable work schedule, then I'm going to pull up the formula that is in the regulations. Because for that, if you have a part-time or an employee who doesn't have a set schedule, then what we do is we look at the average number of hours that the employee worked in the previous 6 months, or if they've worked less than 6 months for the employer, we look at the entirety of their employment. And we take the average number of hours they worked each day during that 6-month period and then multiply it by 14. So interestingly, in that circumstance, an employee will be having what is effectively more than 2 weeks of emergency paid sick leave, because it's their average number of hours worked per day times 14, where the maximum of 80 hours for a full-time employee in general is going to be 2 weeks worth.
Right. Excuse me. Someone has asked about posting, and it's a two-part question. Is there an available poster, and how must it be distributed? The Department of Labor has provided a poster that can be downloaded from its website, and it's easy enough to find at dol.gov. It can be posted, it can be sent out by email to all employees, it can be mailed, it can be put on an intranet or other facility that would be available to all employees. And the goal would be to get it out to people.
Okay, we have a question that it applies to both of these leave laws. Does the emergency paid sick leave apply only to employers with less than 499 employees? It's actually less than 500. So both of these leave laws are limited to employers with fewer than 500 employees, or another way of saying it is 499 employees or less. We also have a question. What if my company uses a general PTO category for vacation and sick leave and doesn't have them separate? Does this create an issue? The recommendation here is that companies, either internally or through their payroll company, create separate categories for emergency paid sick leave and expanded FMLA leave, or whatever we want to call this particular FMLA leave, so that you can track the amount of hours and what you have paid for both of those very special limited time leaves. And the reason for that is it will help you defend a claim if one comes that the leave was not provided. And arguably more importantly, it will help the company obtain reimbursement, that dollar for dollar reimbursement through tax credits, through payroll tax credits down the road. If you combine this particular leave with your normal leave, then it will be very difficult later for you to unpack that and demonstrate which leave was your regular leave and which leave was this COVID-19 leave. And particularly if the leave is related to childcare under the sick leave, or any of the three categories under the sick leave that's at 2/3 pay, and then the FMLA is at 2/3 pay, that's a separate category from anything that would be 100% pay. And so you don't want to get that confused either. So we recommend creating separate buckets for these two types of leave.
Another question that I've seen that has come in is, if your company granted FMLA leave because at the time of the request there was no teleworking that was available, but then telework becomes available, can we ask the employee to perform work? And if we do, would they need to return from FMLA leave as the result of an agreement to telework? And what would happen is the calculation of the 12 weeks would be modified, because instead of working toward 12 weeks of FMLA on a full-time basis, if you now entered into an agreement with the employee to work sometime, the time that they were working would no longer be accumulating towards the 12 weeks of FMLA leave. But it all hinges on an agreement with the employee.
Okay, we have a question about whether an employer is obligated to pay for the time of an employee who wants to be tested for COVID. That's an it depends. If an employee is displaying, or if they tell you that they have symptoms, and the symptoms are specific, pertaining to the cough, the fever. If an employee is displaying symptoms of COVID-19 and is obtaining a medical diagnosis, which includes testing, then that would qualify the employee for emergency paid sick leave at 100% of their regular rate of pay. If the employee just says, I want time off to go get tested, I don't have symptoms, but I've heard that you can be positive even if you're asymptomatic, and I just want to be sure, that is not a qualifying reason for emergency paid sick leave. We're getting close to the end, so we will respond to a few more questions that have come in, but please know that the PowerPoint will be distributed via email in the next few days, so you will have that. There's a question about whether retirement facilities are exempt from the extended FMLA, and that is a arguably yes, because a retirement facility is a facility that provides health care. Most of them have their own wellness center, and there are healthcare providers on site. And while the way the law itself is written provides an exclusion only for healthcare providers themselves, the Department of Labor has expanded the definition of healthcare provider in its regulations to include anyone, whether they themselves are a licensed provider, that anyone who works at a facility that provides healthcare, and that includes certain senior living and retirement communities, they can be excluded. They aren't necessarily excluded. The employer has to make the decision to exclude the employees from both the emergency paid sick leave and the emergency expanded FMLA leave.
The regulations are broader than the statute, and the regulations, as when you get the slide, you will see lists various types of facilities and then has a catch-all phrase at the end, but it is not definitive. But we think a reasonable argument exists for it.
Okay, and all right, why don't we do 2 more questions, and then we'll be finished by 2 o'clock. Question about documentation. The question is, if an employee is caring for an individual who is subject to a recommendation to quarantine, but there are no test results available, what kind of documentation is the employee to provide? The employer can require the employee to provide the name of the healthcare provider. And that's true if the employee is saying that they need emergency paid sick leave because their own healthcare provider has recommended that they self-quarantine, or if the employee needs emergency paid sick leave because they are caring for an individual who has been recommended to self-quarantine by that individual's healthcare provider. So the employer can always request that backup. It's not a note from the doctor per se, that is not required, but you can require the employee to provide the name of the healthcare provider that made the recommendation to self-quarantine.
And I saw a question that came in, my words, not the words of the question, but will hours the employee does work based on an agreement be paid at full rate for those hours or continue at the 2/3 pay rate? And I think it's pretty clear that if the employee is working, you would be paying them at their traditional wage rate. And it is the 2/3 rate that we talked about that would apply if they're on leave. But with that, I would like to thank everybody for their participation and for their attendance, and for attending today and for asking questions. I always enjoy the opportunity to answer questions that come up during these presentations.
Yes,
So
thank you for joining us today.